If your name is not on the mortgage, you may think you have no claim to the family home. That's one of the most expensive myths in divorce, and believing it could cost you everything. In this video, I'm going to show you exactly what your rights are, what your real options look like, and how to make the right decisions about the family home without giving away more than you should. According to the Office for National Statistics, women are the primary caregiver in over 70% of divorcing households with dependent children. Yet many have no legal ownership recorded on the title deeds for the family home, and that gap can leave them dangerously unaware of the protections that they actually have. Not being on the mortgage or deeds doesn't mean that you don't have a claim in divorce. Now, the court looks at the whole picture, including your contributions as a parent, a homemaker, and a partner. A woman that I specifically know spent 15 years raising her kids and supporting her husband's career. Her name wasn't on the mortgage, and the court still awarded her a significant share of the home because her contribution was recognized as equal. Get a homes right notice registered on the property title as soon as possible if the family home is not in your name. This is a legal protection that stops your husband from selling or remortgaging the house without your knowledge. And the land registry can help you do that really quickly. Now that you know that your rights to the family home exists, whether your name is on the property or not, let's talk about what actually happens to that property during the divorce process and the decisions that you need to make. So there are three options for the family home in divorce. And these three options tell you what could happen. Now, most people will only know some of these, not all of them. And that limited thinking can really cost you. So I want you to know that you do have different options. And the first option is to sell the family home. You sell the property, you pay off the mortgage, you use the proceeds to pay any expenses like estate agent costs, solicitor's costs, anything like that, and you split whatever is left. And that split doesn't have to be 50-50. It could be that one of you gets a greater share because you need it, and that could be agreed in advance, or it could be ordered by the court. This is the most straightforward way of dealing with the family home, and it is the cleanest financially, especially when there's not enough equity for one person to buy the other out and be able to buy their own property. Or maybe it's the easiest thing because you both want to buy smaller homes, maybe you want to move areas. So it's definitely one to consider. The second option is to transfer it to one of you. Now, if this happens, one of you will own the home and the other person potentially could keep something else, like money, investments, and or their pension. You may need to take over the mortgage if there is one in the family home, and you would need to do this in your sole name if you're keeping the house. Now, there may be enough money or investments there to pay off the mortgage as well as transferring it into your name. And if that is, that's great because you won't need to get a mortgage. This keeps the house in one person's hands without selling, and that can be a real benefit because it means that there are less costs of sale. It means that if you've got children, they've got stability. But you do need to be honest with yourself. Can you really afford the mortgage on your own, afford the bills, the maintenance, anything else that comes along with the family home? The other option, the final option, is a measure order. Now, this is where the court defers the sale of the family home, usually until your youngest child reaches 18 or finishes full-time education, secondary education. You can stay in the home in the meantime, and the sale of the family home happens later. Or it could be the transfer of the family home happens later. And this trigger event could be your youngest child reaching 18. It could be when you start cohabiting with another person, if you remarry, or if you choose to sell early. Now, this can seem like such a relief because the family home does not need to be transferred. It can stay in joint names if you're not able to get a mortgage at the moment. But it does keep you financially tied to your ex for years, which is a problem. And the courts don't like that so much. So it's definitely worth thinking carefully as to whether this suits your situation. And generally, with this type of measure order, you would be paying the mortgage and bills and day to day maintenance, although structural repairs could be shared. So, which of these options feel closest to your situation right now? And it would be really interesting to know what your thoughts are. So, drop it in the comments below so I know whether this is something you're considering and I can cover it in more detail in further videos. Knowing the options is really useful, but the bigger question that a lot of people skip past is if you get it wrong, this can follow you for years. So, should you fight to actually keep the family home? And this is something that so many of you forget to consider. And I know when I went through my own divorce, I was also fighting to keep the family home. And I said I'll do 3 jobs if it meant I could keep it. I would rent out a room to a lodger. I'd convert the garage into an annex and get rent. I'll do anything to keep the family home. But it took me many years to realize that actually this wasn't the right option for me. And sometimes, although this feels uncomfortable to hear, it might not be the right option for you. Because the honest answer is it isn't always the right option, and sometimes it's definitely not the right option. So imagine someone like me, I was in this situation. I spent years fighting to keep the family home. And I didn't get to that point where I actually took that step, but imagine that person took that step and gave up her share of her ex-husband's pension and kept the family home instead. The pension was actually worth more than the equity in the family home to stay in a property that she could barely afford to run. And then within 3 years, she had to sell up anyway because she couldn't afford the mortgage and she'd already lost pension rights. This happens quite often and more often than people realize. So it's definitely worth considering. Pension wealth is generally overlooked by most people when they're looking at their financial settlement. And the reason why that is, according to research published by the Pensions Policy Institute, is that pension assets are routinely ignored or undervalued. And then this leaves generally women significantly worse off in retirement. Trading the house for the pension is sometimes not the right move, especially if you don't have a good pension provision of your own. So before you decide whether you want to keep the family home, ask yourself 3 honest questions. Can I genuinely afford the mortgage on my income alone? What am I giving up to keep it? Is it pensions, savings, other assets maybe? And in 5 years, will keeping the house have made my life better or harder? The house does have emotional weight. I do get that. And I that was the reason I thought about keeping the family home too. But sometimes financial security matters more than bricks and mortar. And I did end up having to sell the family home and buy a smaller property that I could actually afford. And it gave me so much more freedom with the children. It gave me freedom to set up my own business and to live the life that I wanted. And there is also something worth saying around the children. Many people think that they should keep the house to give children stability. And I completely understand that instinct, and that was me. But children also need security. They need to be in a calm and financially stable parent, far more than they need the same 4 walls. So if keeping the family home stretches you to breaking point, it doesn't serve you, and that means it doesn't serve them. So if you have decided you want to stay in the family home or you want to at least explore it, There is a specific process that you need to understand. And there is one part of it that people consistently get wrong. So I'm going to cover that next. What the court actually looks at when deciding at the family home is important. And it may be that whether you end up in court or not, these are still the same factors that you should take into account and should shape any sensible negotiation. Under Section 25 of the Matrimonial Causes Act, the court will consider a range of factors. And the welfare of the children under 18 is always the first consideration. That is the court's starting point. They are always priority, and it should be your starting point. But after that, the court looks at the financial needs of both parties, the length of the marriage, the standard of living during the marriage, each person's income, each person's earning capacity, the contributions that both of you made, and that contribution is financial and non-financial, so contributing to the family, any physical or mental disability that either party has or the children has. It is important for you to take all of these factors into account to work out whether keeping the family home is the right thing, whether it is fair. And crucially, the court doesn't start from a starting point of 50-50. It starts from a position of fairness. And fairness looks different in every case. It's not the fairness that your ex says. It's not the fairness that you might believe. It's these factors that I've just listed to you. And when those factors are taken into account, you are more likely to get to a fair financial settlement, including a fair situation around the family home. So, for example, a 20-year marriage with children and a significant income gap will look very different in a financial settlement to a 3-year marriage with no children and both parties working full-time. According to data from the Ministry of Justice, the vast majority of financial settlements in England and Wales are reached by agreement rather than by a judge at a final hearing. That means the negotiation you have with your ex, or even with solicitors or through mediations, that's where the real decisions get made. So understanding what a court would do gives you power at the negotiating table, even if you don't actually set foot in a courtroom. So make a list of your Section 25 factors as they apply to your situation. How long were you married? What did you give up career-wise during that marriage? What are the children's needs? What are your needs for housing, for expenses, for retirement even? What's the income gap between you and your ex? The clearer you are on all of this, the stronger your position in any negotiation, with or without a solicitor sitting next to you. Now, there's one more area I want to cover, and it's the one that catches people generally off guard. It's about what happens if your ex is uncooperative and delays things or refuses to engage with you, because that does happen, and you do need to have some options available to you. So if this does happen, and it does happen so often, you might find that they stop paying the mortgage to create pressure on you. They may claim that the house is worth a lot less than it actually is to reduce your payout if you're keeping the family home. And these are tactics that people use all the time. And they can feel terrifying when you're already going through this process and you're overwhelmed, you might be exhausted, and you might be just tired of dealing with this. But if your ex is refusing to cooperate with you around the sale of the family home or the transfer, the court does have a power to make an order without their agreement. A judge can order a sale or appoint a third party to sign documents on their behalf if they're not cooperating, and deal with any deliberate obstruction. So you're not completely powerless, even though you might feel like that. If your ex has stopped paying the mortgage and your name is on it, contact the lender immediately and explain what's going on, because this is going to affect your credit file and you really don't want that to happen. It's so important. Get a copy of your credit file straight away so you know where you're up to before this happens. Many lenders have a process that deals with customers going through divorce, especially if there's financial abuse. Don't ignore mortgage arrears because they will affect your credit and your ability to borrow in the future. Let them know early. You can also register the matrimonial homes right notice that I mentioned earlier at Land Registry if your name isn't on the deeds, because that means that your ex can't sell the property or remortgage it without your knowledge or consent. And it doesn't cost anything to make that application. Land Registry doesn't have a fee for it, but it does give you real protection and actually means that you've got a negotiating strategy. So if this is your situation right now, write it in the comments. Let me know so that I can help you. You're not alone in this, and dealing with it can mean that I can help you to make sure that the videos I do can cover what you need. If you are in this situation where you're trying to figure out what to do with the family home, then I have a masterclass coming up. It's a free masterclass. It's called What Happens to the Family Home on Divorce, and I go through this information in a lot more detail. So click on the link below to join me to register for this masterclass. I'll be going through more insights, more strategies, and answering your questions live.